In today's case, you will see that the contractor wanted to be paid an extension of time claim for a claim that was still sitting at arbitration, meaning the arbitrator had not yet made a ruling on this decision. But the contractor went ahead and went to court to ask for the court to make a ruling that they must be paid for this extension of time claim, which they are still proving in arbitration. In most times, I say this with the letter of demands, where as a service provider or as a contractor, yes, you have a claim, and maybe the claim is valid. But instead of relying on the contract and following the process to prove the claim, we go and write a letter of demand. Then a letter of demand comes to the employer, for example. But the employer then responds and says, okay, I note your letter of demand. I take note of it. But I'm still waiting for you to prove 1, 2, 3, 4, 5. Why are you saying you're entitled to this claim? And maybe for all we know, you have the documents and you have the records that you can pull forward to prove the claim. But I think most of the energy or most of the frustration, because money, if you say you're entitled to it and you're not getting it, can frustrate or is frustrating, right? But now instead of channeling that frustration into how can I prove this claim? Okay, what do they want? Okay, they want invoices. Where do I get them? They want what daily records. What can I pull together to prove that I am entitled to this claim and I must be paid for this claim? But when you go and get the letter of demand, or you go to the court, like the case we're looking into, then the first thing the court attaches is what? The contract document. Because in any court process, when you're going because of a claim or a dispute in relation to any contract, you must attach that contract. Meaning what? We are going to rely on this contract to make a decision. Now, in this specific case, we have a case with a case number that started in 2021. The decision was issued in 2023. That's 2 years, right? And then when we look at the appearances in this case, you'll see that some were senior counsels, some were attorneys. Now, paying a senior counsel or paying attorneys from 2021 to 2023 to go to a court when there is an arbitration contractual process that is happening, only for the court to send you back to the arbitration. How is that helpful? And I think, because I know we have attorneys listening to our channel, we do have advocates listening to our channel. The request would be, when a client comes, especially for construction contracts, when a client comes and says, I am entitled to this, I am due this X amount of money, right? I am due this X amount of money. We must first try, before rushing to court or before drafting the letter of demand, try and say, what have you tried to do or what have you done to prove this case? So that in the process, we are also helpful in getting to the issue at hand.
Visit our website to see our available courses. You can book yourself or your team. See you soon.
My name is Lesego Mpirime. You're welcome. In today's case, we are looking at the High Court case which happened in the Western Cape High Court here in South Africa. The case involved Umlazi Civils, who is the contractor. It involved Concor Construction, who are the employer, and it also involved BVI Consulting Engineers, who are the FIDIC engineer. So the contract in this specific case is a FIDIC Red Book contract. So it's a FIDIC construction contract. So Concor Construction, who is the employer, is responsible for the designs. However, Umlazi Civils, who is the contractor, is responsible for the construction works in terms of this contract. Now, the case has to do with a claim. Umlazi Civils has put forward a claim for 6.7 million plus interest. Now, the claim has to do with an extension of time, meaning Umlazi Civils has done work, but they have run out of the time allowed in the contract. Now, the position put forward by Umlazi Civils is that, one, the engineer had approved the extension of time. So when Umlazi Civils saw that they will be running out of time, they revised their program. They call it Rev 3 program. They revised the program, took it to the FIDIC engineer. FIDIC engineer approved it. Now, if you look at a court case on page 4, which is what Umlazi also relied on with regards to the program, it says that if an extension of time is granted, the contractor shall be paid such time-related preliminary and general allowances as are appropriate, having regard to any other compensation which may already have been granted, right? Now, what is key for me in that specific is for you to understand that if an extension of time is granted, the contractor shall be paid time-related allowances, which means the time extension and the payment of your allowances goes together, which is what Umlazi Civils is relying on as part of its position. That's one. But two, Umlazi Civil says that there was an interim payment which had this value of 6.7 million. And this interim payment was signed by the FIDIC engineer. So according to Umlazi Civils, the FIDIC engineer who is managing the contract, the daily operations of the contract on behalf and is appointed by Concor Construction, one, approved the time extension, two, signed the interim payment certificate, right? So Umlazi Civils is expecting to be paid the 6.7 million plus interest. However, that payment is not coming through. We'll get to it when we get to the employer's position. Now, if you go to page 14 on the same case, if we get to page 14, I want you to see that under paragraph 23, the contractor's senior counsel who was representing them in this case argued that the interim certificate constitutes a binding admission of indebtedness by the employer. So according to Umlazi, because the FIDIC engineer has signed the interim payment certificate, therefore it is binding and it is an admission by the employer to make the payment. That's the position from Umlazi. So they want to be paid 6.7 million, right? Now let's see what the employer's argument is, or what the employer's position is in this specific case. Remember I said the employer is Concor Construction. Now Concor Construction, one, they reject the interim payment. According to Concor, if we look at page 2 on the case, Concor says they, as the employer, did not sign the interim payment. It was only signed by the contractor and signed by the FIDIC engineer. Now, why is that important? If you go to page 2, which speaks to the duties or the authority of the FIDIC engineer, you will see that the employer has limited the duties or has limited the authority of the FIDIC engineer as to what the FIDIC engineer could approve and what the FIDIC engineer cannot approve on behalf of the employer. One, if you go to page 2 on this clause 3.3, it says, the employer's approval shall also be obtained before taking any action under subclause 8.4. That's the first one. Meaning the employer's approval must be sought, must be obtained before taking any action under subclause 8.4. Now, if you go to your FIDIC Red Book, you will see that subclause 8.4 deals with extension of time. Now, what did I say earlier? Umlazi Civils is relying on a REF3 program that was approved by the FIDIC engineer. But when you come and look at the duties of the FIDIC engineer, it is limited in terms of subclause 8.4, meaning the FIDIC engineer must seek approval from the employer before approving any extension of time. That's one. Two, the FIDIC engineer's role was also limited in terms of the performance certificate, meaning the FIDIC engineer cannot issue a performance certificate to the contractor without first seeking the approval from the employer. Now remember, the performance certificate is the certificate that confirms that the contractor has done what was required of them to do, and the performance in terms of construction, installation, commissioning, testing, defects, and whatever else that was involved has passed the test of performance. The FIDIC engineer cannot on his or her own give that certificate without first seeking the approval of the employer. That's two. Now it also says subclause 13.3, which is the variation procedure. Remember, the variation procedure is what we explained in the other video where we were talking about compensation events. So the FIDIC engineer in this contract cannot implement or approve a compensation event, which is a variation procedure under FIDIC, without first seeking approval from the employer. That's 3 limitations already. Now, the other one is contractor's claim under 20.1, meaning the FIDIC engineer on his own cannot agree, accept, approve, or handle a contractor's claim without first going to seek approval from the employer. Remember what I said at the beginning. The duties and authority of the FIDIC engineer are similar to the duties of the project manager. To say, you have been appointed by the employer to manage the contract on behalf of the employer. Meaning the employer did not relieve himself or herself from the duties in the contract. Yes, you are managing it, but at certain approval stages, you need to go back and seek approval from the employer, especially in instances like these where we are talking about extensions. Because remember, as the FIDIC engineer or as the project manager, you would have had the authority delegated on the money at that point, on the time at that point. Meaning, if you're going to run out of the money or you're going to run outside of that time, it means you are now operating outside of your own mandate as the project manager, or you're acting outside of your own mandate as the FIDIC engineer. So before you even accept, approve, or anything else, you go back to the employer and make sure the employer is in agreement, then you proceed, right? Now, how does this come back here? Umlazi Civils, if you remember in their argument, they said, our program was approved by the FIDIC engineer, our Rev 3 program was approved. And then they also said, we have a signed payment certificate from the FIDIC engineer. But now, because the payment is not coming forward, we are here, right? So now the employer's position is, no. The interim payment, I will not pay for it because as the employer, one, I did not approve it. And then two, the employer says they have done another interim payment, or they have done an assessment as the employer's team. And according to this assessment, a holistic assessment, it shows that Umlazi construction was also in delay. Remember, the 6.7 million is an application for, or is a claim for extension of time. Now, the employer says, okay, but we have done an assessment and it shows that you are requesting for extension of time, but within those same periods, you also had your own delays, meaning they were concurrent. They call them concurrent delays, where I'm late, but you are also late. And our delays are happening almost at the same time, which means I cannot pay for your own delays, right? Now the employer has done an assessment, and the employer says, from the 6.7 million claim that you want, and from the delays that we have seen or assessed as the employer, you can only be due 613,000. Not 6.7 million, but 613,000 rand. That is what the employer says is due to Umlazi Construction, and that is what the employer is willing to pay to Umlazi Construction, Umlazi Civils. Now it comes, okay, the last argument or the last position that the employer put on the table in this case was, this case, as it's now at the High Court, it's also at arbitration. So the employer was asking the High Court to say, don't make a ruling on this case for us to pay Umlazi Civils, because the very same case that you will be dealing with as the High Court is also in front of an arbitrator who is looking at the merits of the case in terms of the contract. That's the third request. So now, to take you through the stages as to how they ended up here. When Umlazi and Concor identified in terms of the contract to say there is a dispute, whenever there's a dispute, the very first stage is an adjudication. So Umlazi Civils followed the process. They issued a notice of dispute. A dispute was raised to the adjudicator. The matter went before the adjudicator. Now, at the adjudicator, Umlazi Civils lumped up the extensions of time claims. So they have 5 claims all in all in this case. The 5 claims making up 6.7 million. And then at the adjudication, they dealt with the issue as a global claim. Now, a global claim is just a consolidated group of claims. So at the adjudication, the adjudicator in his decision indicated to say they did not look at the merits of the claims, meaning the adjudicator did not look at the merits of the claims. Why? Because according to the adjudicator, the accepted viewpoint was that the REF3 program was accepted. Meaning, if you accept the program according to the adjudicator, and in terms of the in terms of the dispute, if we go to page 7, in terms of the dispute, the adjudicator says, no. The dispute was only in relation to the quantum. The quantum means cost. The dispute is not about the extension of time. So the adjudicator says, in your notice of dispute, hence we must be very clear in our notice of dispute what is in dispute, right? So the adjudicator says, the notice of dispute that I have received only speaks to quantum, the cost, meaning there's a dispute on cost, but there is no dispute on time, meaning the adjudicator then does not see the need to open up each claim to verify or to do an assessment on each claim to see if there is any merit or if there is any concurrent delays, like the employer is saying. So now, in the stage of adjudication, the adjudicator ruled in favor of Umlazi Civils. Now, I said you must look at page 7, which says the employer did request, if you go where it speaks to mandate, it says, I do not consider it necessary to open up and correctly determine the validity of the claims forming this dispute, right? And then it says, since the engineer on behalf of the employer has already ruled, right? So the engineer on behalf of the employer has already ruled that the claims are valid. This is according to the adjudicator. And it says only the quantum of the relief is in subject of this notion of dispute. You remember the limitations of duties that we went through. it was clear that the FIDIC engineer cannot approve without first consulting the employer, even on the program, which is the 8.4. But here, according to the adjudicator, he confirms that no, the notice of dispute in front of me, because remember, the adjudicator gets his mandate from the dispute referral as to what is the issue in dispute that he needs to decide on, or that she needs to decide on. Then here it only said quantum. And again, now because they lumped up the 5 separate claims into one global claim, it then made the adjudicator to accept the cost as put forward by Umlazi Civils, and the adjudicator ruled in favor of Umlazi Civils to say, okay, Concor Construction, you need to pay Umlazi Civils. That was the adjudicator. Now, Concor Construction gets the decision, and Concor Construction is not happy. They are not happy with the adjudicator's decision. But remember, in terms of your FIDIC contract, same with most of the construction contract like your NEC, an adjudication decision is binding. You only have a number of days or weeks that you are given for you to put forward a notice of dissatisfaction to say, I am not happy with this adjudicator's decision. If you don't put forward the notice of dissatisfaction, the adjudicator's decision becomes binding, and binding means you must do what the adjudicator said. So now in this specific instance, Concor, being the employer, says, no, I don't agree with the adjudicator's decision. I'm putting forward, I'm complying with the contract, I'm putting forward a notice of dissatisfaction. Okay, and the notice of dissatisfaction is put forward, and then now the matter goes to arbitration. Remember, it's adjudication, arbitration. Now, when it moves into arbitration, if we check page 5 of this court case, it says, in terms of the arbitrator, it says they provide a final settlement of any unresolved dispute by arbitration. Meaning you went to arbitration, it's unresolved, you still don't agree, then it moves into arbitration with the notice of dissatisfaction. So it says it gives the arbitrator or arbitrators full power to open up, to review, to revise any certificate, any determination, any instruction, any opinion or valuation of the engineer, and any decision of a DAB relevant to the dispute. So the arbitrator has powers, full, here it says full power. The arbitrator has full power to open up any instructions in relation to this dispute. So you can't come to the arbitrator and say, just look at this. If the other party wants them to look at more, they will bring more, and it is allowed, right? So in this specific case, they went to arbitration, and what happened at arbitration? They agreed to say the arbitrator must give an award on what is this one? The arbitrator gave an interim award. Remember, interim always means temporary. When you hear the word interim board, interim what, it's temporary. It's not permanent. Or it's the first one, there's something else coming. So this is interim, but something else will follow, right? So the arbitration gave an interim award. What is interesting to note is at this arbitration, the contractor, which is Umlazi Civils, remember at the adjudication, they got the approval from the adjudicator because they did not open up each of the 5 claims. They lumped up the 5 claims into a global claim, right? But now during arbitration, according to the papers, it says Umlazi Civils abandoned the global claim. So they abandoned the lumping up of the claims, meaning as requested previously by Concor Construction. The decision from the High Court, one, dismissed the application. So the application was dismissed because remember, they wanted, Umlazi Civils wanted to be paid 6.7 million. So the decision from the court dismissed the application for 6.7 million. Why? Because the case is still in the contractual process of arbitration, right? 2, the court granted the employer to pay 613,000. Remember when we go back to the employer's position, the employer said, I don't agree with 6.7 million, but I agree from my own assessment as the employer. I agree with 613,000, which I have assessed and I'm willing to pay. So all the court did was informing or instructing the employer to proceed to pay what the employer had assessed, while the rest of the claim is going into or is under arbitration, right? And then, but what are the lessons that we can take away from this case? The biggest lesson for me is, as service providers or as contractors, can we avoid rushing into letters of demands for claims or variations that we must still prove? Because the only thing that will happen is, okay, I see your letter of demand, but I still need you to prove 1, 2, 3, 4, 5. So in this specific case, they went to the High Court. The case number is in 2021. The decision was issued in 2023. So there's 2 years of paying senior counsel. There's 2 years of paying attorneys, possibly specialist experts in the process, for something that is still under arbitration, still under the contract for you to prove. But now we are asking the court to make a ruling on something that we are supposed to be proving, right? That's 1. 2, the understanding around interim payments. Remember, in any construction contract, interim payments are included in the contract to make sure that as the service provider, you are not out of pocket. You don't do work out of your pocket, no. You do work, it gets assessed, you get paid. You do work, it gets assessed interimly, right? At the end of the entire duration, there is a final payment assessment done, or the final account done, to prove that yes, indeed, the progress of the work and everything else aligns. But in your NEC, all the contracts, whether it's term service, whether it's your professional, all the NEC, there is interim payment certificate, including your FIDIC, all your FIDIC books. There is interim payment certificate, meaning the interim payment can be reviewed, can be opened up, and if there was a mistake done, or if there was an error done in any of the payment certificates, it can be corrected at a later stage. I remember there was a case where in the final account, it was seen that an incorrect CPA calculation was done. What did that mean? All the interim payments that were done previously had to be opened up and corrected. But in that specific case, it was to the benefit of the contractor, because the contractor was actually undercharging in the CPA. But during the final process of the final payments, you are able to still open up and correct, but it can be for the benefit of the employer or it can be for the benefit of the contractor. But the contract itself does allow for an interim payment to be corrected. So now we've seen in this specific case where the contractor was of the view that no, the interim payment is final, it's binding. If the FIDIC engineer has signed it, it must be paid, and that's it. That's why this case is now in the court, right? But the court have shown that no, an interim payment is not final, is not binding. It can be corrected and opened up. I hope we get that. And then the other thing, Concor Construction, who was the employer in this case, understood their duties in this contract, understood their rights in this contract. Remember, one, the FIDIC engineer approved an extension of time or approved the program. Then the FIDIC engineer signed the payment certificate, giving the contractor the right now on this dispute to say, no, I'm entitled. You've approved it, I'm entitled. But Concor came and said, no, as the employer, we don't agree. Because as the employer, the FIDIC engineer acted outside of his mandate. He cannot do an interim approval by himself as the FIDIC engineer. He could not extend the time beyond the time completion as the FIDIC engineer by himself or by herself. So as much as the FIDIC engineer is employed and is managing the contract on behalf of the employer, the FIDIC engineer is not the employer. There are rights that the employer still reserves for himself, right? So the employer was able to defend this case and not just make payment on the basis that no, the person who's representing me agreed to this. Yes, they agreed to it, but they were acting outside of their mandate. And you can call it as the employer and say, okay, they agreed to this, they signed this, but I am still saying as the employer, I'm not going to pay for this because I don't agree with this. So in this case, the employer, which was Concor Construction, understood their rights, understood the limits that the engineer was under, but was able to challenge the matter. So there's a distinction between you representing the employer or you representing the contractor, to say you are representing, right? But you are limited in your delegation or you are limited in your mandate. There are certain things, even if you're representing the service provider, that you cannot agree to until you get a go-ahead from the service provider to say, can I do this? or from the employer to say, can I do this? Because remember, the contract is between the employer, the contractor. Thank you so much.
Visit our website to see our available courses. You can book yourself or your team. See you soon.